I'm with Vrinda Grover, an advocate with the Supreme Court who has filed a public interest litigation, who had filed a public interest litigation on behalf of an IPS officer on the Bilkis Bano case. I'm Jyoti Malhotra with Avaz South Asia, and today, of course, we're discussing the Supreme Court, which has cancelled the remission for 11 people, 11 convicts who had been convicted in the rape and the gang rape and murder of several of Bilkis Bano's families. This was back in 2002. Ms. Grover, thank you so much for speaking to me on Avaz South Asia. We are live, and I just wanted to ask you, tell us what this means. What is the meaning of the Supreme Court judgment today on the Bilkis Bano affair?
I think it's a very important and landmark judgment. And we will recall that the entire case relating to Bilkis Bano is located in one of the a moment in Indian politics history in 2002, when she and her family were fleeing from their village, and there was a targeted violence against Muslims in Gujarat, and about at least 14 members of her family, including a 3-year-old daughter, a little baby, were murdered before her eyes by this mob, and women were gang raped, including a pregnant woman, and Bilkis was 21 years old at that time. The Supreme Court had early on transferred the investigation to the CBI, and the trial of the case, looking into the facts and circumstances of the case, it had transferred it to Maharashtra, where there were all these 11 men were convicted on all counts, multiple counts of murder and rape.
Right.
And this conviction has been upheld in all appellate courts. They secured remission from the state of Gujarat earlier in 2022 after serving 14 years of life imprisonment.
Right.
That was challenged both by Bilkis and in public interest litigation petitions. The court has today, in its verdict, very categorically spelled out that this remission is contrary to the rule of law. The rule of law grants the power of remission to the state.
Okay.
But that remission power was not available in this particular case to the state of Gujarat, which exercised the power.
Okay.
And it has in fact said that Gujarat state appears to have acted in tandem with the convicts. And it had no power, no jurisdiction, no authority to grant them remission. And it has usurped this power. This power, both under the Code of Criminal Procedure as well as judgments of a constitutional bench judgment of the Supreme Court, lies with the state of Maharashtra, because the state where the convict is sentenced,
right,
that the state will have the power to grant remission, which in this case would be the state of Maharashtra. And therefore it says this power has been usurped by the state of Gujarat and has struck it down because this order is wholly illegal. But I think the larger point...
Ms. Grover, I just wanted to ask you, now there seems to be, in my mind, because I was just reading this judgment, but also the Supreme Court last year did allow, there was this one convict, I think by the name of Radhesham Bhagwan Das Shah, who had petitioned, I think claiming sort of mercy that they had on the basis of good conduct in jail for 14 years, that they wanted to be now released or given bail. So what was the role of the Supreme Court last year, which allowed this case to come up right up to the Gujarat High Court? So just explain, because there is some contradiction in my mind, and I think in the mind of a lot of people who have read this judgment. If you could explain that, please.
Okay, so one of the convicts, Radhesham in particular, moved first the Gujarat High Court, saying that my remission application, and the convict is entitled to move a remission application at the end of 14 years, as per the policy earlier. He said my remission application should be considered. The state of Gujarat, relying upon the Shriharan judgment of a constitution bench of the Supreme Court and Section 432, subsection 7 of the Code of Criminal Procedure, rightly held that no, the state of Gujarat has no power. If you wish to apply for remission, apply to the state of Maharashtra.
Okay.
After which he did apply to the state of Maharashtra. He moved his application there.
Okay.
And of course, there were some authorities who are necessary authorities in the process of remission who held that, such as the Special Judge of Mumbai, the CBI, the Superintendent of Police of Dahod in Gujarat, and others who said this is not a fit case for grant of remission given the nature of the offense and other factors.
Okay.
Why that is so, there clearly it was not going to work in the convict's favor.
Right.
He then moves, and another convict had moved to Maharashtra seeking a transfer from Maharashtra prison to Gujarat, which was done for almost all of them. And they were then serving their sentence in Gujarat, which is allowed as per law.
Okay.
Now, the state of Gujarat order saying Maharashtra is the appropriate government in law was never challenged by anybody, including Radheshyam. So that order was never appealed against, no challenge, no petition filed in the Supreme Court. Thereafter, a fresh petition gets filed under Article 32, which therefore has to make out a case of violation of a fundamental right by Radheshyam, saying, direct the state of Gujarat to consider my application because there appears to be some confusion and contradictory stance taken by state of Maharashtra and state of Gujarat. Now, this was a misrepresentation to the Supreme Court because state of Maharashtra had not opined on the aspect of who should consider the remission application. That had never come before the not state of Maharashtra, the High Court of Bombay. It had never come before the High Court. In this fresh case that was filed, which should have been struck down on multiple grounds, who were the parties before the court? It was the convict seeking that his application be considered in accordance with the 1992 policy and the state of Gujarat.
Okay.
Bilkis Bano directly impacted, and let us not forget, the victims in this case is not only Bilkis Bano. If so many people were killed, they have their families also.
Sure.
None of the victims, including Bilkis Bano, was before the Supreme Court arrayed as a party. So here you have Radheshyam and you have state of Gujarat. State of Gujarat did not bring to the attention of the Honorable Supreme Court certain very material and relevant facts. Today, the court has therefore held that that order was passed in May 2022 on suppression of relevant facts, and in that manner, a fraud was played upon the court. And since the Gujarat state was cognizant of an earlier order of the High Court of Gujarat, it was a duty of the Gujarat state to file a review once the May 2020 order was passed, May 2022.
But Ms. Grover, couldn't the Supreme Court have done its homework? I mean, I fail to understand. This is the Supreme Court, the highest court of the land. Couldn't the Honorable Supreme Court have done its homework? And also, the Bilkis Bano case is something that every citizen in the country knows about. So if you have the state of Gujarat being represented and this convict Radheshyam being represented, I mean, isn't it sort of common sense, if you don't mind me saying that, to ask where is the person who has, against whom this injustice has been done? So,
well, I would agree that yes, it would have been important to have heard her. If they had heard her, they would have known that this was a fraud being played upon them.
Why didn't they hear her?
Because it is said that, see, the victim should not necessarily, I think there are multiple complex jurisprudential principles involved here. Should the victim be heard at this stage? All the person is saying is, consider my application. I would actually say the problem lies with the state of Gujarat having utterly and completely failed to discharge the duty it owes to the court, and having remained conveniently silent, and therefore, in very strong terms, for the Supreme Court to today say that you are working in tandem with the convicts and in complicity with the convicts. I mean, this is the most scathing indictment that the Supreme Court can ever make of the state. And the state of Gujarat failed to bring to the attention or to file a review petition. And so the court passes an order. The order was also against a judgment of the Supreme Court. The state of Gujarat had to file a review and say, this order is erroneous. That was not done. So when the parties are before the court, I think there is a more fundamental issue here. The
Okay.
fundamental issue is that courts function by having faith in what is said on behalf of the state. How does the court hear matters? How does the court understand what is happening? The court doesn't have eyes and ears everywhere. If the state makes a submission, the court takes it in good faith. Here, there is a breach of that. And so that had to be turned around. And the court has today put the state of Gujarat in the dock. I understand a convict is going to perhaps hoodwink the court.
Right.
But there's a state standing there. Does the state not owe a duty to the victim?
So Justices B.V. Nagaratna and Ujjal Bhuiyan, who have delivered this judgment today, they have chastised the Gujarat government.
Oh, very severely. It's a scathing indictment. And in fact, they have said that you appear to have worked in tandem with them and said this actually refers back to why this case, in its facts and circumstances, was transferred at the first instance. They seem to have, we don't see the state of Gujarat acting in accordance with law even today.
So what was the response? Was there a response by the state of Gujarat?
At the pronouncement of judgment, nobody responds, and they will respond in whatever they wish to file now.
So what happens to these 11 convicts who have been...
They have been directed to surrender within 2 weeks. And of course, they are free to use the legal remedies available to them, including of seeking remission, but now from the state of Maharashtra. And the court has said you cannot give this arbitrary or mass kind of orders. They have to be orders in accordance with law. And one can, I think what the central message the court has given today is that rule of law is the central pillar of Indian democracy, and rule of law will prevail to protect all and to ensure that justice is done to all, including women. And it doesn't matter who the accused are or what is the, what kind of affiliation somebody may have. The equal treatment of law will be upheld by the court.
So, ma'am, so in these next 2 weeks that the 11 convicts, like you said, they are free to appeal to the government of to the High Court of Bombay for further, for a remission in their cases. But does this mean that after 2 weeks they have to go back to jail? Is that correct?
Well, unless they are, I'm sure they will. Their lawyers will see what kind of reprieve they can secure for them. Failing which, yes, they have to go to jail. Otherwise, there will be warrants issued against them.
So they go to jail, and if any of them or these 11 convicts, if they do go back to jail, does this mean they go to jail for the rest of their lives?
Well, they have rights of remission under the law, and those rights are available to everyone. They will have to secure remission from the appropriate government, the state of Maharashtra, and the relevant policy. And hopefully this time round, the letter and spirit of the law of remission will be respected and adhered to, and rubber stamp, cyclostyle, stereotyped orders, which the court has commented on these remission orders, that they will not be stereotyped, cyclostyled, arbitrary orders.
Right.
The court can only ask the state to adhere to the rule of law.
So what happens to Bilkis Bano?
Well, I think Bilkis Bano continues to remain the symbol of a woman's struggle for justice when she's pitted against those who the state decides to protect and shield. And it's a story that every Indian should be haunted by, that this is what it means when a woman seeks justice for mass crimes, the most egregious of, what in international law would amount to war crimes and hate crime is committed against her and her family members. This is the manner in which she has to struggle for justice, and we are in 2024. I think it's something that should haunt each one of us.
So 22 long years after this horrific crime was committed. It's going to be 22 years next month in February. And Bilkis Bano seems to have got the justice that she wanted, perhaps not fully yet, because I'm not sure what kind of compensation she gets. But if any, the monetary compensation is never going to compensate for what she went through. But thank you so much, Vrinda Grover, for speaking to me on Awaaz South Asia. Thank you so much for your time.
Thank you. Thank you.